Court is on the record in two cases. In the 25 CRB 47 case, Mr. Hazeltine was convicted of one count of resisting arrest, a second-degree misdemeanor, was placed on supervised probation with this court. In 24 CRB 399, he was convicted of attempted aggravated possession of drugs, a first-degree misdemeanor. Again, that was entered on December 30th, 2024. He entered no pleas to the probation violation complaints at the March 6, 2025 hearing. And today these cases are set for a final revocation hearing. Mr. Hazeltine is appearing from the Conneaut City Jail. His hearing is being recorded utilizing whereby.com. Mr. Hazeltine is represented by attorney Philip Heasley. Mr. Heasley is in the courtroom appearing at table 2 on the video. Also in the courtroom are Law Director John Lewis and Probation Officer Sean Benoit, who are appearing at table 1 on the video. Court is in receipt of a report. Mr. Lewis.
Thank you, sir. The offer that has been extended to Mr. Hazeltine would be to admit the violations filed in both cases. With that admission, the city would recommend a jail term of 60 days, and that Mr. Hazeltine would be then continued on supervision until his terms of supervision have ended. And Mr. Heasley has indicated to me that Mr. Hazeltine is going to admit the violations today, sir.
Thank you. Mr. Heasley?
That is correct, Your Honor. I've discussed, including prior to today's hearing, Mr. Hazeltine's situation with him. He has been in jail since March 5th, and we are in agreement with those recommendations. He's aware that the court does not have to follow the same. Thank you very much.
Thank you. Okay, Mr. Hazeltine, it's my understanding today that you wish to enter guilty pleas or admit to the probation violation complaints filed against you in both of these cases. Is that what you wish to do today?
Yes, that's correct, Your Honor.
Thank you very much. The court does find that the defendant and his attorney have executed in open court the written waiver. The court does find the defendant's plea of guilty or admission to the probation violation complaints to be knowing, voluntary, and intelligent. The court will accept the guilty pleas, and I will therefore find him guilty of violating his probation in each of these cases. Okay, Mr. Heasley, is there anything your client would like to say at this time in mitigation of sentence?
I'll just say, Your Honor, Mr. Hazeltine has, on these cases, been incarcerated since March the 5th. We would hope that the court would follow recommendations for sentencing in these violations. We're aware that the court does not have to do so. It's my sincere wish for this individual that he gets the treatment he needs, and in order to do that, he's got to comply with the rules of treatment. He has been very forthright with me about acknowledging issues. He does wish treatment, and of course, because it's not provided, he is not getting that while he is in jail, and that would go for any jail in the county. So we would hope, Your Honor, that the court impose that which has been recommended. It is my understanding that this court's probation department continues or wants to continue to work with Mr. Hazeltine, and I would hope that whatever is ordered, that this individual would comply with those orders. He's in his early 30s, Your Honor, and he still has much life left to live, and I would hope that he would get things straight, and it's up to him to do so. That's all, Judge. Thank you.
Thank you. Mr. Hazeltine, is there anything you would like to say at this time before I impose sentence?
I'd just like to say I take full responsibility for what I've done and my actions, and I'm okay with getting with what I deserve to do.
Okay, Mr. Lewis, anything further?
I have nothing to add, Your Honor, at this time. Officer Benoit, that wants to add.
Thank you. Officer Benoit.
Just think that we've made numerous attempts to get him into treatment and bent over backwards to get him there. And each time it's come back and just hasn't complied. We got him out early, jail day, a few days early, I believe. He made it a day into the treatment facility and actually left the facility, Your Honor.
Is he serving a jail sentence on any other cases? He's just being held on this case, these cases?
I believe that's correct.
Okay. Yeah, Mr. Hazeltine, you know, look, we deal with those who are battling substance abuse and mental health disorders every day. And unfortunately, Mr. Hazeltine, you haven't hit rock bottom. As much time as you spent in prison and in jail, and as much time as your life is a total mess, you have not hit rock bottom, which is just mind-blowing to me. That you have not hit rock bottom to realize that you need help and that you really desire to receive help. I entered you into renewal court. We had the assessments all scheduled. You were out in the run. You were out here. You're doing all of this. I released you from jail. We couldn't even get the assessments and screenings done. And then we order you to go to Turning Point. We have you transported directly from the jail to Turning Point. You walk out. And I specifically asked you that. At the time, I says, now, Mr. Hazeltine, I asked, are you going to walk out of Turning Point? And if you do you recognize the consequences you face, Mr. Hazeltine? And you absolutely said, yes, I do, Judge. I sure do, and I need help. Well, you haven't hit rock bottom yet, because if you really felt that way, you would have stayed. And instead, you walked out. I'm done with you, Mr. Hazeltine. I don't know what else to do for you. Your record is a mile long. For a guy who's your age, you have spent more time in jail, it seems, or in prison than you have outside. And it's continued. I mean, you got a big break in one of these cases by having a felony reduced to a misdemeanor. And yet you continue. You continue to just not care. I don't know. That's how I interpret it. You don't care. Because you haven't hit rock bottom yet. So I'm giving you the maximum sentences in both of these cases. Bear with me. 168 days of jail in 24 CRB 399. I will give him credit for 12 days of jail that he spent from March 5th to March 17th, 2025. This is consecutive to the other sentence in 25 CRB 47 of 76 days. He actually is entitled to jail credit as well in that case. So he will be given an actual jail sentence in that case of 64 days. Because he's been held on cash surety bonds in both of these cases. So 156 days plus 64 days, so he's got 220 days left to serve. I'm advising Mr. Hazeltine of his right to appeal, of his right to appeal without cost, of his right to have counsel appointed on appeal without cost, of his right to have documents provided and necessary to file an appeal without cost, and of his right to have a notice of appeal timely filed on his behalf. He will be unsuccessfully terminated from supervised probation in each of these cases. Anything further, Mr. Lewis?
No, sir.
Mr. Heasley?
No, sir.
Okay, these matters are.
So what I liked on that was it was super quiet, just nice and easy going, just quiet as could be, and then all of a sudden the judge just unloads on them on the end. This is a small little court in Ohio. It's an awesome little one. I've got a feeling that at the bottom there's more tables and such, but we can't see them, so we can't ever see there. But every once in a while, this one gets some good little sovereign citizen idiots wanting to go through there. Congratulations, Jess and Dwayne. I always want to call you Jess, but it could be Dwayne, so I don't know who's ever typing. So I'm going to assume it's Jess. Let me know over there. Oh, we got CJ today. How are you doing, CJ? It's tomorrow there, so thank you for coming in. We got Judge Simmons, Judge Boyd. I've got some Clayton County magistrate. We got a damn goofball coming in. This is first appearances for it, but let's look at that Clayton County. This is where Judge Tammy Hayward is. This is the intake part of it.
O para tener discusiones legales con respecto a los hechos específicos de su caso.
So at no point the interpreter is just talking here, but look at that goof in the bottom right corner. His case will come up in a minute, but he's just goofy as hell.
Informarle de algunos derechos específicos.
Set bond on those offenses for which the court is authorized to set bond.
Asignar una fianza en aquellos delitos que este tribunal está autorizado a asignarle fianza.
Schedule a preliminary hearing.
Programarle una audiencia preliminar.
Determine whether you require the assistance of an attorney.
We're going to be doing Beverly Morrell first.
Sir.
Or can you repeat his name?
My name is Minister Dr. Morale Leon Beavers.
Bevers.
Mr. Bells?
Minister Dr. Morale Leon Beavers.
His name is Bevers, man.
Yes.
Okay, hold on one second, Mr. Beavers. Mr. Beavers, you are charged with entering an automobile. Bond amount set for you is $5,000. You were ordered not to return or go upon the premises located at 4. That's in Forest Park, Georgia, 30297.
Yes, ma'am.
Deputy, Deputy?
Now,
I have not received the court-appointed attorney applications. Did you guys send that over to us?
This is like
So Kimby, I thought he said doctor. So he said pastor. I don't know, but I thought he said doctor. In the end, he's just a homeless guy. He's getting charged with entering a car. So he's just kind of goofy. And Nancy, I do believe he's single, so you might want to reach out. Yeah, Debbie, I'm assuming that someone get a Judge Juice Box. Absolutely. Every time I watch her, I keep kind of feeling like it's a TV show, like she's just acting like a judge. But I guess that's disrespectful. She does a good job.
man, they've been sent over. If you need me to send them over again, I'll go send them again.
Okay. Mr. Beavers, are you planning to hire an attorney, represent yourself?
please.
I'm sorry?
So in this court here, whenever the deputy is talking to the inmate, they mute it on their end, and you can see the judge. You can see her almost like rolling her eyes on it. I don't think she cares for it too much, but it's every time the deputy starts to talk, he'll mute it on him. We're gonna go back to it.
Ma'am, so you get a paycheck, man. I don't do pro se to myself, but I'll let somebody get a paycheck, man.
I'm sorry.
No, my phone don't work. Ma'am, I would like to hire an attorney, ma'am. Yes, ma'am, so they can get a paycheck. Instead of pro se represent myself. Okay, I'm not saying, sure.
Hey,
I plead guilty. I did open the car door. You want to get
All
the
right,
film?
sir. Okay. Without going into the facts of your case, are you currently employed?
I'm a Social Security benefit share, and I like freedom of speech too.
Okay, so you're not currently employed. Okay, what I'm gonna do is I'm gonna go ahead and appoint an attorney to represent you. Your next court date is 4/16/2025. All right? Do you have any 4/16, April 16th, 2025?
All right, man. Come on.
All right?
Okay, hold on. Another question. What's the day there, man? I'm gonna be in jail a month, 4/16. Oh.
Oh, hold on, wait, Judge. Let me bend it down so you can see.
Yeah, so this one here is pretty sad. Wait till you hear how I'm gonna have to take the comments off there. Yeah, wait till you hear what she's in jail for and how messed up her case is.
Okay.
Me and Ross. Is Ross is it Ross for the second one? Judge,
Yes,
is that male or female?
ma'am. Good morning, Ms.
Ross.
Mias.
Good morning.
Counselor, are you ready to proceed?
Yes, Your Honor.
Okay, you can go ahead. You can go ahead, counsel.
Okay, Judge, my understanding is that this is not an offense bondable by this court because it's a conspiracy to commit rape. So I anticipated you setting a hearing.
Yeah, what I have listed here as the offense is just party to commission of a crime. That's all we have listed on our end. There isn't an underlying offense or an attaching offense. So obviously you can see where that puts us in a sort of strange position.
It's a very strange warrant if you read it.
Yes.
The allegation is that she busted in to find her husband allegedly in an act of another woman who was quite upset, and the officer has seen fit to charge her with a party to that crime.
Right.
I would ask for a signature bond. It's an absurd charge. I'm in the process of talking to the DA's office to get it dropped now. It's ridiculous, to be honest. And so I would ask for a signature bond for Miss Laura to be able to return. She has children. There's no basis for this warrant, even if on its face it fails. So I would ask the court to release her on her own recognizance.
I do agree, counsel, that on its face, the warrant is pretty vague. Like I said, the only offense I have listed here is party to commission of a crime. It doesn't allege what crime was committed, so it's pretty precarious. However, counsel, I am a bit concerned about the seriousness of the charges. I am concerned about the alleged victim involved, and just the nature of the underlying offenses. And so what I have done, and I am going to give her a preliminary hearing date, is I have gone ahead and I have set a bond for $5,000 today.
Thank you.
I am also going to include a stay away provision from Michelle Valencia and Jose Lara, and not to return to 296 Roy Huey Road, number 14B in Riverdale. I'm not sure if that's the residence for her and Mr. Lara, and if she'll need to go back there to get her belongings.
I believe that is the residence for the alleged victim.
Okay.
But I would ask the court to reconsider the no contact with her husband. They are married legally. I don't object to not talking about the case, but that is her husband, and there's no allegation. I mean, if anything, the warrant itself sets out that, she might be mad at him, but there's no allegation that they're doing anything illegal by discussing or by being married and being together.
And I understand counsel's position with regards to that, but unfortunately, I'm looking at the warrant on its face, and the information I have from the warrant does list Mr. Lara as being involved in the underlying offense, although the underlying offense is not listed as a charge. So unfortunately, counsel, for today's purposes, I'm going to leave the stay away provision as is. I am going to give you the preliminary hearing date of it's 4/16.
Thank you.
And at that point, I'm hoping that, some of these issues will be properly fleshed out, and maybe the judge at that hearing will be able to reconsider some of those conditions.
Thank you.
Okay. All right.
I'm sorry, just to be clear, the bond was set for 5,000?
Yes, sir.
And once we post the bond, the preliminary hearing date goes away.
Well, yes, it does. There are conditions posted on it, so that's something you can just check to see.
Ah, good point. Thank you.
Yes. All right.
Thank
All right,
you.
Mr. Moniz. Have a good day, sir. Thank you for your patience this morning. I appreciate it.
Great day, Judge. Thank you.
You take care.
So she caught her husband with another woman, and the woman got so scared she called the police, and she's got she got some charges in there. It's the weirdest damn thing, and the judge was right to, be kind of cautious on it, and the lawyer was right to say it's insane. Hey, Fletcher boy, good to see you out here today. Oh, yep. I need to stop learning from the news. Absolutely. I look. I've got to the point now to where I couldn't even tell you a news channel anymore. So the news has gone away.
Thank you. Bye-bye. Attorney Baker, while we're waiting for your clients, would you like to waive
Yes,
the
Your Honor.
reading of the extradition hearing, or would you like me to go ahead and read?
I'm okay with waiving. Our whole entire goal is to get him processed sooner.
Okay.
So if he could sign the waiver, give, I guess Las Vegas is the agency. They're 15 days to come pick him up, but we don't need the reading. I think he has a
Okay.
great understanding of it.
Okay, no problem. When he is that Mr. Ross, deputy?
Yes, ma'am.
Good morning, Mr. Ross.
Good morning.
You are charged with fugitive from justice. Your attorney here has represented to me that you have waived the reading of that extradition order and that she's gone over this information with you and that she's properly informed you of what it is that needs to be done. Is that correct?
I haven't spoke to an attorney yet. I spoke to my attorney in Las Vegas last night, and they were working today. So I don't know if that's how this came about. But yes, I'm as fast as I get back to whatever I need to do.
Okay.
Yes, Your Honor. Just to clarify, I did speak with his attorney in Las Vegas, and I informed him of the next steps, including your girlfriend, I believe. I forgot her name. I was under the impression that they relayed the message to you. But they just retained me yesterday, like 8 o'clock, Your Honor.
Yeah, and I haven't been able to talk to them since I spoke to them. So we haven't had a phone call since then.
Would you like a breakout room for us to discuss it further?
We can do that, or I can just go ahead and read the.
Just read it off, Your Honor.
Okay,
yes.
Thank you.
Okay. All right, sir. Good morning. Again, I am Judge Rochelle Gordon. This is a hearing for what's called an extradition issue. That means that a fugitive warrant has been issued for your arrest. You do not have any charges here in Clayton County. You have brought before our court today because you have charges pending in, I believe it's Las Vegas, Nevada. And that state is requesting that you return to answer the charges that you have pending there. In accordance with the laws of the state of Georgia, you're brought before me for an explanation of these proceedings. And counsel has agreed that she's going to waive everything here. However, you have the right to contest the legality of this warrant and all the extradition proceedings, or you may waive your right to the extradition proceedings and voluntarily be returned to the state that's requesting your detention. And it appears as though, from what counsel has said, that's what you would like to do. Before you inform me. Okay.
Yeah.
All right. So if you decide that you're going to contest it, which it doesn't appear that you're doing this morning, then you would have to follow the procedures for that. But counsel has determined that we're not going to need to go through that process. Is that correct?
Yes, Your Honor, that is correct.
Okay.
And then can I meet after this with counsel?
Yes, I'll be there. Okay. I'll be there at the jail later on today to meet with you.
And just to clarify, you're doing this freely and voluntarily. Is that correct, sir?
Yes, yes, ma'am.
All right, counsel. So we will get the paperwork together, and we will have the court will have him. The sheriff's office will have him sign the necessary documents. Okay.
All right, we're going to jump over to Judge West. Judge West, it's good every once in a while to get her. She gets a little excited with people.
Good morning. Are you Anthony Mendoza?
Yes, ma'am.
And Mr. Mendoza was previously in court and entered pleas of true to counts 1 through 13 in a motion to revoke probation. Currently on probation for driving while intoxicated, third or more. That was a 6-year sentence that was probated for 6 years. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor. Yes, Your Honor, we have.
Are there any additions or corrections to that report?
No, Your Honor. Not from the state judge.
All right, Mr. Parker, you may proceed.
Well, a couple of things I want to address. It's a situation I see quite a bit where he's ordered to have to scram and interlock. It's costing $600 a month. And he's having to go to work, but yet he's not supposed to drive. And so he's driving with an invalid license. And then he's not able to work, and he can't afford to pay for the things, he needs to do, such as the 12-step program, the GED program, all those things require money. And that's one of the big issues. But the things I'm concerned about is that it says that he went to the safety relapse program. I'm not sure exactly what happened, but he says he never went to the safety relapse program. I don't know if he was ordered to go and he didn't go, but I think he was in custody at the time, and I'm not sure how that happened. But he also says he's never tested positive for cocaine, which is alleged in here. It addresses an issue that he apparently had with one of the directors of the facility where he became combative. And this also, in turn, is tied to a scram device. He ended up developing a big sore on his ankle, so he would put his sock behind the scram device. And in this incident, he was frustrated, and he wanted to take his boot off to show the director the problem that he had. And that's when they were saying that he was being disruptive. He has no other felonies, Judge, and he wants opportunity to go back he wants to complete his probation. He wants to do the safety relapse. I'd like to hear what they say and what happened with that, but I'm sure there's an explanation. And I think you'd also like to address the court, Judge.
Well, let me first make sure I've got the timeline, because it appears that I see that safety he completed and then was placed on zero tolerance in the high medium caseload. And after that, there was an issue where he was testing positive, again, for alcohol and cocaine, which I understand he denies the cocaine, but that's what this alleges. And in October of 2022, I'm assuming through an administrative hearing, was granted relapse safety.
Yes, there was a motion to revoke that was filed and came before the court, and he was ordered to go to relapse safety, and he absconded, and he never went to relapse.
So he wasn't in custody?
No.
Okay. And then, so we didn't see him again until August 11th of 2023, when he was arrested in Houston. So here's the thing. Whether you probably didn't get any paperwork, come up here to the front in the middle here. From at least October of 2022 until August 11th of 2023, you wouldn't have known about anything because you quit going to probation. You were an absconder. And the only reason we found you is because you were arrested in Houston for aggravated assault with a deadly weapon. And then in May, we get you back here, and you were sanctioned to 180 days in jail. So this is the third time, it looks like to me, that you would have been given an opportunity to remain on probation. Gave you upfront time, continue you on probation. Courtesy supervision was sent to Harris County. And then we have the scram device issues still, alcohol violations, interlock violations, aggressive behavior, ongoing alcohol use. So if you didn't do the relapse safety, it's not anyone's fault other than your own, because if you didn't know about it, it's because you weren't going to probation. Mr. Nichols?
Judge, I think it's pretty clear. He was put on zero tolerance a couple of years ago, and here we are on the second time.
Third.
Multiple times.
Yeah.
And I don't know what else we could do. So obviously I agree with the probation department's recommendation for revocation. I think he's had more than enough chances, Judge. In fact, there's just one thing I don't make the court aware of. If I can call Ms. Martinez real quick.
Yeah, sure. Ms. Martinez, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Go ahead.
Ms. Martinez, you were supervising, Ms. Mendoza was on Harris County supervision, correct?
Yes, sir.
And you were back in October when he started having these violations and the warrant was issued. Did you advise him to turn himself in?
Yes.
And what was his response to you?
He had responded with an email that said, "Ha."
That was his only reply to you. Did I ask you to print me out a copy of that?
Yes.
Showing you what I'm marking?
Hold on a second. So he replied with just a ha? Everybody, are we meeting Micah Sacco on TV? I don't know. Micah, let us know if that's you. Wave your hand if that's you, bud.
Mistakes Exhibit 1, for purposes of this hearing, is this a copy of the email with his reply to you?
Yes.
I'll tender to the defense attorney, Your Honor. I'll tender to the court. For purposes of this hearing, I'll offer State's Exhibit 1.
It's admitted.
And is that pretty consistent with his level of cooperation and attempts to prevent probation while he's been supervised?
Yes, sir.
No other questions, Your Honor.
All right, any questions?
Just a couple. I want to clarify on the relapse program. You said y'all came to court on motion to revoke. Is that my understanding?
Yes.
And so the safety relapse was ordered by Judge West.
Yes.
And when he was here, the defendant was here. Mr. Mendoza was here at that time?
Yes, sir.
Well, wouldn't he have been taken into custody?
Let me make sure, because I wasn't supervising.
Okay.
It looks like the hearing was completed over the phone. Okay, wait, he wasn't on here. It was over the phone with the supervisor at that time. Due to him residing in Houston, he reported he had a lack of transportation to report back to the hearing at that time because he had tested positive for alcohol and cocaine. The supervisor had recommended complete relapse safety and issue a warrant for his arrest. So he was made aware at that time that he was going to have a warrant and we were requesting relapse safety.
I have no further questions of her, Judge.
All right, anything
I have no
else?
other questions for Ms.
Your Honor.
Martinez.
Thank you, Ms. Martinez.
I think he wanted to address the court, but we never did because
Sure.
we talked with her.
Go ahead.
Would you like to tell the court? Do you want to tell the court?
Y'all saying I went to safety twice. I never went.
Nobody's saying you went to safety twice. We're saying you went to
You're saying
safety.
I'm
Hold on,
absconding?
don't, listen. I'm gonna let you talk, but don't talk over me. We're saying that you went to SafeP and then that you were ordered to go to the SafeP relapse, but you never came and turned yourself in after that phone call where you were told that there was to be a warrant for your arrest. So no, you never went to SafeP relapse. Go ahead.
She said I was supposed to turn myself in. That was after I did the 9 months where felony assault got dropped to a misdemeanor terrorist threat.
Mm-hmm.
So when I was here, y'all let me out. And then I was trying to work and they kept saying that I was messing with the spam device.
Okay.
So I was actually at work when she sent me the message to my phone. And I was trying to work and trying to pay, for the devices and stuff, since they were violating me for operating my truck without court permission.
Mm-hmm.
So that's when I just didn't turn myself in.
Right. So did you respond? Is that email? That was
Yes, ma'am.
that's what you thought about all that?
Yes, ma'am, I did actually send that.
You thought that was funny?
It's because I was agitated and I was taking lunch at work, and I was trying to do things trying to make money to take the classes, but with being on the scram device.
Well, you had money to buy alcohol. You had, because you kept drinking, because you kept messing, I mean, Mr. Mendoza, you have been given so many opportunities on this probation, and I understand that those things are expensive. However, if you had at any time stopped testing positive and having blood alcohol readings that were positive on those things, then you could have eventually gotten off of those. I don't keep people on those for very long, but the reason we had to keep doing it for you is because you kept drinking. You kept messing up. And so you don't get to say, I kept messing up. I mean, seriously, you got the initial probation in 2021. You got you got SafeP, you got some upfront time because of the Harris County issue, didn't revoke you, haven't revoked you, 3 times haven't revoked you. And here we are with all of these violations.
Through the TDCJ program, I was doing what I needed. The only time I had issues when I had the foot problem that I got from the halfway house. That's the only reason they said I absconded from the TDCJ program.
Okay.
I've actually done well through the program, through with the supervised division. The only time I messed up is when they stopped supervising me and made me go do these things by myself.
Well, I mean, how old are you? How old are you?
I'm 43.
43 years old.
And I have no felonies on my record except for this.
That doesn't mean anything. You have this felony and you have 6 years hanging over your head, and you've been given all the tools. You went to SafeP, you got aftercare. At some point, you have to take those tools and do for yourself and not come in and say, well, they made me do it for myself, so it's somebody else's fault that I kept drinking. We gave you the tools.
If I can
We're done. At this, we're done. No, we're done. Mr. Mendoza, turn around. You can say whatever you want, but you're going to face me and you're going to get your sentence. And if at this time I could give you more, I would, I promise you, but I can't. So I'm going to find that you entered your pleas of true to counts 1 through 13 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time revoke your probation. Sentence you to 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you a certification of your right to appeal. This was not an agreement, so you do have some rights to appeal. Y'all need to sign that before you leave right now. You need to sign that you're getting a copy of it, and then we'll give you your copy, and then when you're done with that, you can go back with the bailiff. Huh? I know. I thought about lots of things. None of them would have been appropriate, but all of them crossed my mind.
May I excuse you?
Yes, it's probably a good thing, Mr. Parker. Okay, I just don't even know where to go next.
All right, it's good to see that judge cut up a little bit. She's normally so straight laced on it. So, yeah, that's 43. At least I start. It keeps me from feeling so childish. You know, I may act petty and stuff, but I think he has me beat on that. All right, let's go to a Judge Boyd one. We hadn't done Judge Boyd in a little while. Let's throw her up.
All right, court is calling 2025. Where's CR 001442 State versus Patricia Adams. Can I have parties announced for the record for the state?
Rick Pena for the state of Texas.
Defense.
Michael DeLeon for Ms. Adams.
And are you Patricia Adams?
Yes, ma'am.
Did you understand you're charged with assault, family, household, or member with a previous assault conviction? That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Outside the agreement, the state is recommending that your deferred adjudication be for a term of 3 years, 150 hours of community service restitution, the HMAC and TAP evaluation, and follow all recommendations. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? All right, what is HMAC?
Hostility Management Area Control.
All right, people love their acronyms, right?
In speaking with probation, I probably should have spelled it out.
No. I always like to know.
I didn't know what it was either, Your Honor.
Okay.
If we want to go off record real quick, I can probably.
I'm sorry?
If we want to go off record real quick, I can probably explain what it is to answer.
Oh, no, I know what the anger and hostility course is. I just didn't know those were that was the acronym.
Okay.
So, all right. My motto is always, if you don't know something, ask. I always tell my students, what's a dumb question is not asking, is the unasked question. Everything else, we're finding out information. So I've learned something new today. All right, so to the offenses charge, how do you plea?
No contest.
Are we proceeding with sentencing?
We are, Your Honor. I do have one ask.
Yes.
Ms. Adams is in yellow because she recently had a baby a month ago at the jail. So she's currently not working right now. We were wondering if the court would be consider probating any of that fine, $1,500. That was my big ask because she's getting back on her feet as far as when she's out. And we're asking the court to grant her application for deferred and to allow her to do the TAP evaluation outside of jail.
All right, I'll probate the entire fine. So here's my question. I read this police report. Why are you hitting on your mom?
Your Honor, it was honestly, she assaulted my dad and I kind of acted on fear, heard my dad screaming. So that's the reason why I kind of assaulted my mom.
Well, that's not kind of, and it doesn't mention that in here. And what, your father, is that Mr. Adams?
Yes.
All right, that's not what he says in this police report.
Well, that's what happened in the true situation.
Why are you living with them?
At the time I was staying with them because my dad had lost his Social Security and my mom was the only one that had Social Security and I was trying to be my dad's provider. So that was that situation and, money became an argument in that.
No, that's not what she's saying. She's saying you wanted to lay in bed with her and she said no.
Your Honor, I have my own air mattress. I didn't have to lay with my mom.
So, I mean, do you want a jury trial? Because it's sounding like counsel, she's saying none of this is true because in the report, it says that your mother had a swollen, busted, and bloody lip, that the officer immediately noticed it. She declined medical attention, and she stated that you had been staying at the motel with them. Victim states that you and her do not get along. It says that you went to lay in the same bed as the victim, and the victim told you to get up and move, and that caused an argument. Victim stated that she attempted to leave the location multiple times, but the suspect, that's you, was not allowing her to walk out the room. Suspect pushed victim multiple times away from the door, then punched her in the face one time with a closed fist. Suspect then grabs the witness's cell phone from the bed and fled the location. Witness 1 witnessed the assault and stated that suspect did push the victim and punch her in the face. Witness is disabled and bedridden. Victim provided information on suspect, and after running her information through CAD, it was determined she had a prior conviction of family violence. Then, are you saying that you didn't take your father's cell phone?
It was mine and I had literally just got paid that day. So that's the only reason why I took my phone back.
All right, they're saying it's his phone because they said, I contacted the suspect over the phone with the phone number provided that was witness's cell phone. And it says, you state, I'm not coming back to the location and I did not assault the victim. And it says in here that you told them that the victim purposely hit herself to make it look like she was assaulted. And now you're telling me something different.
I didn't call on saying that she hit herself. I
That's-
admitted to the police officer on the phone that I did assault.
no. That's not what this says, unless you're telling me the police officer just like, let me make something up in this story and put in here that she said she never hit her and that the victim hit themselves.
Judge, I've had extensive conversations with Ms. Adams about the particular situation. And while there's some dispute about the factual situation, overall, what it boils down to, and Ms. Adams agrees, is that she did hit her mother. That did occur. Circumstances around it are a little fluid, but overall, she does want the court to proceed with deferred adjudication. And she believes she can be quite successful on deferred.
How old is your mother?
She was born in 75.
All right, how old are you?
25.
You shouldn't be hitting on your parents. You shouldn't be hitting on anyone. And honestly, because you have a previous conviction for assault, I don't even know why you should be trusted around children, honestly, because it appears that you have a temper. And that hasn't been sufficiently addressed because you're here for another assault. And it's another family assault. State, you wanted to add something because you came up?
I did want to add that we're just requesting that the evaluation is recommended by the state be actually done in custody.
Okay. All right. Is there anything else?
Judge, we would just ask to have the evaluation done out of custody.
Right. When's the last time you had employment?
During my around this time, the incident,
Doing what?
my father's providing the rules for women.
All right, I can tell you right now, I don't allow people to be home health care providers for family members.
Well, I was looking for employment at fast food. I'm seeing.
Well, no. We start with what were you doing? And you said you were doing home health care providing work for your father. I don't allow this in this court. And to me, the home health care business is becoming akin to when we first started practicing, everybody was working at West Telemarketing. Now, home health care provider is West Telemarketing for felons. I don't allow people who are on felony probation to be home health care providers. They need to get a job. And home health care providers need to quit just looking at the bottom dollar where they're making a lot of money. Then they just hire random people to come in and watch people. Oh, you can watch them and we'll pay you $10 an hour. And then other things ended up happening. There's no way you should be in charge of caring for anybody because you have a temper that you cannot control. And how many children do you have?
Three living children.
I'm sorry?
3 living children.
All right. And what are their ages?
I have a 4-year-old, a 2-year-old, a 1-year-old, and then a 1-month-old.
And who are they with now?
Right now they're with dad's custody.
All right, what does that mean they're in dad's custody? Was there a hearing? He has legal custody, or you just like, hey, I'm going to jail, here you go?
Well, he's on the birth certificate and I'm incarcerated, so they stay with him and his mom due to my living situation with my mom.
All right, so that tells me that the grandmother is taking care of these children. I don't know why people continue to have children and then they want somebody else to take care of them. But I guarantee you, when these children graduate, when these children ended up being famous for whatever they've done, the parents who did not really care for them, they're going to be telling everybody on the planet, that's my baby. And you know what? Those children should say, no, I'm not. You didn't raise me. So in this court, you're not going to be allowed to be a home health care provider. All right, this is what the court is going to do. There's a $1,500 fine that will be probated. 4 years deferred adjudication. Proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. And there's to be no employment in the healthcare field at all. So these schools where people go to and they're there for 3 months and they learn how to take blood, Not allowed. You understand? There's going to be 150 hours of community service restitution. I'm going to order parenting classes. Once that's complete, 50 hours will be deemed satisfied. How far did you go in school?
I got my GD.
All right, what are you planning on doing with the rest of your life?
Honestly, working and taking care of my kids.
All right, I'm going to order, if she completes trade school, 100 hours will be deducted. I'm not requiring you to get a trade school certification, but if you do, 100 hours will be deducted. Otherwise, you're going to be picking up trash off the side of the road in the heat of San Antonio. HMAC. All right, we can go off the record. Here's the thing. Beating up your parent, never a good thing. If you feel as though your parent has not been the best of parents to you, you're an adult. That means that, you know what, mom, dad, you were not a parent to me. So I'm no longer going to have any contact with you. But to fight with your parent, that's a no-no. Think about it. What if one of your children were to start beating you up? It's not a good thing. You need to watch the movie called Imitation of Life. It's not so much about her being physically abusive to her mom, but she was emotionally abusive to her mom. Then when her mom dies, guess what? She is running down the street, crying, telling everybody who will listen, that's her mom. We only have our parents for a small window on this planet. And trust me, if your parents are here till they're 100, it's still never enough time. So you're going to have to change your ways. You understand? All right. Good luck to you.
Thank you, Judge.
Thank you.
Before they both leave.
Yes. Yes.
One, sir. One.
I don't want to beat her up. She's already in jail, but imagine just how bad you'd feel having a kid in jail. Just you're certainly not thinking you're on your way out of trouble. Now when this girl talks, she's 25 years old, 3 kids, and when she gets out of jail, she's going to do the right thing and get a job, take care of her kids, be the great mom she's been all along. And just don't know. Just I guess for the little time I've spent with her, it don't seem like she's the great mom she talks about. So I don't know. Let's see. We got Judge Simmons. I got 2 Judge Simmons clips. I can't remember which one this is, but I am certain it is one of the 2. So let's see what we got with Judge Simmons.
What's your name?
Chase Carson, Your Honor.
What's your name?
Amanda Williams.
Full appearance.
Good afternoon, Your Honor. Jessica Larson on behalf of Plaintiff Oak Sparrow, along with representative of the property.
Okay, today was the date set for hearing for termination of tenancy. Did the parties come to a resolution?
We haven't spoken on this one, Your Honor. From the prior hearing, my understanding is we've got quite a dispute. I don't think that we're in dispute on possession. The tenants are indicating that they actually vacated far before we believe that they did. So I don't know. I don't think that a resolution is likely on this one, Your Honor. I do say that I will say the issue of possession is probably moot because the tenants are indicating you moved out.
I don't know what prior hearing you're talking about. I have a note here. Let's see. Pre-trial. Present. The tenant's no longer in possession of property. There was a hearing for the 18th. Okay, so what happened? You're saying you vacated the property?
Yes, Your Honor. I was served a 7-day on May 24th. I'm new to this whole process. I've always paid all my bills. So at that point, I uprooted everything that I could take, including my family, and we vacated the property. I attempted to make a phone call to Miss Sandy Bristol, fell upon deaf ears, as many communications had to that point. I, at that point, thought this was all behind us, and then all of a
Communication
sudden,
saying that you had vacated, is that what you mean?
yes, I attempted
Okay.
to contact her and let her know the key was on the counter, and we were out of there. No response.
You have record of where you.
I did text her and ask her why on the day of the that I received the 7-day, because at that point it was to my knowledge we were doing everything that we could to stay in the property, because we had previously had a case due over our animal that they tried to evict us and they lost in court, but for whatever reason that still shows up on our record. So when we attempted to go get a new home, when they refused to renew our lease, we have a red flag. I can't rent anything. They won't even show me places. So I reached out to Miss Bristol And in good faith, I said, I will do whatever it is in my power to keep my family in this home. I jumped through their hoops. I gave them record of my dogs. I obtained insurance. They
Are we talking
walked
about
the
this
property.
eviction though?
What's that?
I'm talking about this eviction, not the previous one.
Yes.
Okay.
Yes. So, I'm sorry. I guess I missed it.
Okay, because I thought you were talking about there was another eviction
There
about
was
an
an
animal.
attempt at it. They were ruled against in the
Okay.
courtroom.
So since receiving
that
this notice of
eviction has put-
eviction, that's when you reached
Yeah,
out
that-
that you would do anything?
Yes, after
Okay.
when I attempted to, because then we went back and finished out our lease, and then we got a letter in the mail that they are choosing not to renew. So I was like, that makes sense. And I attempted to find a place. When I realized we were blacklisted and I couldn't even rent a place, then I reached out to them and said, I'm willing to do anything that you would like. And I did everything they like. They walked the property. Everything looked good. There was no damage to the property. And then all of a sudden the letter comes in the mail, you need to leave within 7 days. So in fear of another thing going on my record, I took what we could and we vacated there. We were gone before June.
When you say you took what you could, doesn't sound like you took all your stuff.
No, ma'am. No, ma'am.
Then you didn't turn over possession.
Like I said,
What did you leave there?
I just things that we didn't have space to store or anything. I took the possessions, our day-to-day possessions, and we bounced around since. We were going to make an attempt to clean the place up if that was their request, but again, she did not give me any communication back and forth until we got a new court date.
So you
After
communicated with her in via text after you left?
Yes, I asked
what
her
did you
on the
say?
24th. I said, why? And she says, you have continued to ignore us. You never submitted the animal application, and the dogs were an issue. It's too much of a liability.
Did you
Well,
tell her
I
that you
do have-
vacated? Did you tell her that you vacated?
No, because I hadn't at that point. This was the day
Okay,
that I
want to
received
know
the
what
7 days.
I want to know about you communicating that you vacated.
That was a telephone call.
Okay, you called her.
I don't have a record of the telephone
Did
call.
you
It's
talk to her on
logged
the
up.
phone, or did she not answer?
No answer.
Did you leave a voicemail?
I was not able to leave a voicemail.
Why not?
To be honest, I don't know if her mailbox was full or what have you, but I wasn't able to leave her a message at that time.
Okay, so how was she supposed to know that you vacated?
Answer the call.
Okay. So when you called, let's say she was tied up and busy, couldn't answer. Or maybe technology didn't work well. And she didn't even know you called.
I don't know how to answer that for you. It was a confusing, scary time for me. I have not experienced things like this. I just was like, I put my hands in there. We're out of here. Like I've done everything I
And
can
you
do to
left the
stay
keys
here.
there? You
Yes.
stayed at the property? Okay, counsel?
I'm sorry, Your Honor.
Counsel, did the property appears to have been vacated, but there was a number of things left there?
There was a substantial amount of things there left, Your Honor. From my understanding, the tenants continued to reside there because they were paying utilities there. And so the date of the hearing that I think Your Honor read, that was in front of Judge Buchanan. My client didn't get notice of the utility switchover. There was no indication of keys being left. There was no written notification. There was no verbal notification. Up until that hearing, we had no idea that they were going to even claim that they had moved out back in May.
Where were you still paying?
Well, we had past due amounts, so I was paying the minimums at that time to keep my name from getting to the point where I wouldn't be able to put utilities in my room at the next, or I mean my name at the next residence that we wouldn't be at.
My client didn't get notification of any utility turnover until, again, after the hearing that was before Judge Buchanan back in November.
Which all would have been communicated had her client answered the phone call, but she put me
Well,
on
you
silent.
didn't, you didn't change the utilities over to your new place. Where did you? When you
I
left, where you
can't
moved?
find a new place because.
Okay,
of
so
this.
you don't have a new place.
No, I'm bouncing around, staying with my mother at the moment.
Okay.
This has created quite a situation.
But you didn't disconnect the utilities at the place you was paying about. Yeah, you have some evidence of the utility bill.
No, I don't have evidence of the utility bill.
Yeah. So do you have any evidence of what was left in the property?
I have a ton of videos and photographs, Your Honor. My client has also gone by the property several times and can indicate that the vehicle that Mr. Carson and Ms. Williams, that vehicle was outside of that property on many occasions when she was driven by. There's a ton of stuff outside of the property. There was absolutely no indication that these parties had vacated. There's shoes on the porch.
Show your
There's-
evidence.
And Your Honor, I will say too that the client.
Was there any physical evidence of us being there, or a picture of my vehicle there? Because I can guarantee that wasn't the case. They park in the driveway next door.
Okay.
Well, how would you know where my client
Where are you? If you all want to talk
They
off the
didn't-
record, bye. You can talk outside if you want to talk to each other. If you want me to handle it, then you talk to me. You can talk outside. Next case.
Thank you, Your Honor.
And you've not come to resolution, correct?
We have not. It sounds like we're at an impasse, Your Honor.
Okay, so then you need to talk to me and not to each other. Back and forth is not going to be allowed. If you start back and forth, I got to move on. Look, all these people behind you waiting for their turn.
Apologies, Your Honor.
Okay, I'll allow you to present your evidence.
At this point, Your Honor, it sounds like based on some of the claims that the tenants are going to make as far as the utilities and how those were paid, I'm not able to access that. My client is not able to access a record that is in the tenant's name without a subpoena. So I'd ask the court to allow me to issue a couple of discovery subpoenas and reset this matter.
You said about how the utilities were paid, you mean?
Yes, my understanding is that utilities remained in the tenant's name, that they were paying those regularly until that November hearing of Judge Buchanan. The tenants are now claiming that they were only making the minimum payments and they were paying past due amounts. I'm unable to access those records. My clients have called and they've tried to get them, but the utility companies obviously are not going to release an account in someone else's name. So I think that would be an essential piece of evidence in this case. And so I'm asking for the ability to issue subpoenas to Water Light and consumers.
That's fine. Is the property secured and winterized?
My clients have gone into the property, Your Honor. I don't know if they have, I would like an order actually confirming the possession that they can retake it because they have gotten a notice from the city that they've asked for an extension until Monday in order to remove trash that's from the property. Otherwise, they're going to give the violation.
So there's trash that you're saying that they left. Can I see?
Yeah.
Your Honor, that's something that I'm privy to as well.
Okay, so it's front porch. This is from the code enforcement. They said that there was trash found in boxes, bags, and barrels on front porch, clothing and cloth products on front porch, deteriorated metal product on front porch, loose trash and debris, front porch, in yard, around and behind the house. Did you leave trash at the property?
I guess you could consider it trash. Yes, there were several items that I explained that I had no choice but to leave behind. I didn't have.
No, you have a choice.
I did now.
You do have
I
a
had the
choice.
financial ability to do that.
Did you put the trash there?
I'm sorry?
Did you put the trash there?
There were items in the home.
Did you put the items?
interpreting them as
Did
trash
you
is
put
not
the
correct.
items? Did you put the items that have accumulated causing code compliance to come and issue this concern violation about? Did you put it there?
On the porch, no.
So the things there are not yours. How did they get there?
I don't know. They've had the property.
Do you have
since May.
pictures?
I have some pictures of the exterior of the property, yes, Your Honor.
I can't see what they're.
I didn't ask you to speak right now. Do you have copies for him?
I handed him one.
Okay, I see a helmet. I see a look like child's car, a welcome mat, or something welcome thing. I don't know what
Again,
this is. I didn't ask you to speak over me.
Oh, I'm sorry.
It looks like something else on the porch. I don't know what it is.
It's to be boxes and shoes.
You said boxes and what?
It looks to be 2 empty boxes and a pair of shoes.
What are the toys in the front yard?
Those were toys that my children played with outside that I have nowhere to store it. So they were items that were yet and left behind.
Okay, so there's shoes, there's boxes. I do see debris. You didn't put those there?
I'm sorry?
You saying you didn't put these things there?
That's why I said, is it trash or what are the items so that I can specifically tell you? Like, I wouldn't consider my kids' toys trash, but to each their own opinion.
You left the things here?
Yes, Your Honor.
Then you think that they're supposed to be responsible?
This
for
photo was taken while we still live there, by the way. That item is in our possession. That football helmet is currently in our possession. I don't know where these pictures were taken or when, but that time frame they just gave you is wrong. Actually, multiple items that are in these pictures are currently in my possession.
Could I ask him to confirm what date he's going to say that he moved out?
What date did you move out of the property?
It would have been May 30th and 31st.
My
That
client
was the
took these
moving.
photographs at the end of June.
Any other evidence that you have today?
I have a witness with me, Your Honor.
Take the stand.
Okay.
Solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
You can have a seat.
And are you a representative of Oak Sparrow Properties?
I am.
Are you employed by Sandy's Property Management?
I was in 2024, yes.
Thank you. And are you familiar with the file for Chase Carson and Amanda Moore?
I am.
Have you, and they've lived at, have you, since May of 2024, have you been to that property?
Yes.
More than once?
I drove by the property at least once a month from June until November 20th was the last time, because I was told that they had told the court they had.
And that's all through 2024?
Yes.
And did you observe any changes in the property between May and November?
Yes.
Did items appear to be moved?
Yes.
Did it appear to you that there was somebody residing in the home?
Yes.
Are you familiar with the vehicle driven by either Chase Carson or Amanda Williams?
I've seen Chase put dog into I think it was a white kind of work type van possibly, or a panel. It was, yes.
So you would recognize their vehicle?
I recognized it on the street. I wouldn't recognize it out in traffic.
Fair enough. When on these occasions that you've described driving by the property, did you observe that vehicle?
Once or twice in the street, yes.
And that was a vehicle that you had seen Mr. Carson access?
Yes.
At any point in time over the summer of 2024, did you get any notification from the city regarding any unkept lawns?
No.
Was that an indication to you that the lawn had been kept appropriately in the city? Sure. I'm sorry? You said something, sir?
Do I need to?
I thought he was interjecting. I'm sorry, Your Honor. Have you been in contact with the utility company? And at any point in time, have you received notification that the utilities are being transferred into Oak Sparrow's name?
No.
At any point in time, have either Mr. Carson or Ms. Williams indicated to you or to your knowledge, have they said that they were moving out?
No.
In April, did they indicate that they wanted to renew their lease?
Yeah.
Were you working on actively renewing the lease?
We were actively working on a month-to-month agreement.
What's your objection?
That is not the truth.
Objections are for evidentiary foundation, not that you dispute what she's saying. So if you dispute what she's saying, when she's finished, I'll give you an opportunity to give your testimony, but that's not an objection. So you can continue, ma'am.
Thank you. Did Mr. I want to call him the Carsons. Did Mr. Carson or Ms. Williams turn in their keys at any point?
No, not to my knowledge.
Did you ever receive any written notification that they were terminating their lease?
No.
Did you actually appear at the property on May 1st of 2024?
I did.
What was the purpose of that appearance?
To inspect the home to see if there was any animal damage and to give animal applications and to explain what paperwork the owners have requested in order for them to stay in the property district.
And so that was part of a process of extending the lease.
Correct. Mr. Carson also provided me with documentation for the dog licenses and vet records, which I did copy for him and returned on May 7th. I did not enter the property on May 7th.
So you say that you've gone by once a month at least to check on the property.
Yeah.
And you've seen a vehicle that you believe to be mine there, correct?
A few times, yes.
And what was that vehicle?
I think it's a white van or some type of panel that has doors on the back.
Your Honor, I have no white van. I do not own a white van.
Okay.
I've never.
This is time for you to give or ask her questions, not time for
Oh,
argument.
okay.
Okay.
Sorry. Yeah, that's. And are you familiar? You said you were familiar with neighbors then?
I did not say I'm familiar with the neighbors.
Okay. Are you aware that they have children there?
I did not.
Okay. And are you aware that children will play with toys if they see them, such as a Power Wheel left outside that could move a couple times?
Objection call for speculation.
Just saying that the neighbors next door, they have several.
The question
children
is
that
it
play with
possible?
toys.
Is it possible that the neighbors
Yeah, is
that?
it possible that someone
That,
else?
no, I'm asking you, was that your question?
Yes, Your Honor. I'm asking, is it possible that someone else may have moved a toy outside the home? That's what you're going on
Instructions
for us to be
overruled. You
there?
can answer it.
I guess anything's possible.
Okay. And any of the times that you have drove by the home, did you physically see myself or any member of my family? Okay. And when you called to ask about the utilities, they wouldn't speak to you, correct, about how it works? So it's a good possibility that we were paying the minimums to keep our
Objection,
name from
argumentative.
getting.
Well, that
And
would cause
speculation.
speculation. That causes speculation. You don't have to answer that.
Well, my point, Your Honor, is that in order to get something taken out of your name, you have to pay it in full. This came out of nowhere. I had no means to pay it in full. That explains why the utilities were continued to get paid and stayed in our name right up until the point where they just shut them off. It wasn't turned off because we.
I understand you've cleared that with me
Okay.
with the, as part of why you made those payments. They're asking for a continuance so that they can get the records. I'm just getting their testimony now, so when we come back, we don't have to do that.
I understand.
Do you have questions? Any more questions?
Not for her, no.
Okay, thank you. Any redirect?
Why do you believe that Mr. Carson has ownership of a white van?
I had seen him putting 2 dogs in that van on May 1st. About 5 minutes before our agreed upon appointment, where Sandy, Davey, Bristol, and myself toured the property and spoke with both tenants.
So whether he owned it or not, he certainly had access to it.
He had keys that unlocked, and he opened the door and put 2 dogs in.
No further questions.
You said you had video, or is this what you're talking about?
The video, Your Honor, was taken by another witness who
Okay.
is out of the state at the moment. So if we do come back, I can present that, Your Honor, and have to testify.
Okay, sounds good. I'm going to give you this evidence back for now. You had an issue about the property. You wanted an order?
Thank you, Your Honor. I'd like an order for immediate possession and reserve the money judgment for a continued date.
Well, order for possession is granted. They said they've already turned over possession
That's never been
of
a
the
question.
property. We'll deal with the money judgment. We'll continue for the money judgment issue. Obviously, if they have to clean up trash and debris, that goes towards their money judgment claim. You do understand that, correct?
What's that?
If they have to go into the property to clear out the trash and debris, that costs money. And so that's also evidence that will go towards the money judgment. You
And
understand
now, I don't know if it's possible or anything, but I would have had no problem communicating that with her, that I would be willing to take care of those items and get the property up.
that? You just told me earlier that you had no choice.
So I didn't have the means that within 7 days, but then I could say
No,
I
but
can come back with a truck
It's
when I can afford
it's
it.
been 6 months since
Yeah,
you said you left.
Yeah, and I just assumed they wrote it all off. That's why we're here today.
You could know from that they
And
filed
I
an eviction.
also, go ahead.
They've been on notice of this for several months, Your Honor.
You couldn't have assumed there's been an eviction pending, so you knew that the
And
eviction was still
is it
pending.
general practice for them to drill out the locks and give themselves back the property without a judgment from the court?
It's not general
Okay,
course,
'cause that has
however,
happened.
it's also not general course to leave a property. That's why I asked, was the property secured and was it winterized? Because if you vacated a property, if I take what you say to be truthful, that you vacated a property in May and that you called one time, no one answered, you left no voicemail, you never followed, do not talk while I'm talking. You left no voicemail, you never followed up. You never got any word to make sure they knew that the property was vacant. That means you left the property exposed and any animal, creature, person could come and take over this unit because you just left it abandoned with things there. When you leave things there, they don't know off the top that you have moved or rendered possession unless you notify them. This is if I'm taking what you say to be true. And then on top of that, there's still electricity going to this. So if they check the electricity, they see that's still going on. So there's no reason for them to believe that you vacated unless you have communicated to them that you have vacated. It is now the dead of winter. We're in the middle of a snowstorm. It's going to be 0 degrees. That's why I asked, was the property winterized? Because if it wasn't winterized and those pipes freeze and burst and there's damage to the property, and I make a ruling that you have not properly turned over the possession, then now you're responsible for the damage if pipes freeze too. Do you understand how that works? Okay, so what is it that you feel like so urgent that you need to share with me?
I was just wondering, am I the only one that's responsible for communication? If they had any questions, they couldn't have reached out at any point during this? Do they have any attempts to reach out to me or any of my people
No,
to resolve it?
they did reach out to
Other
you.
than court?
They filed a notice to quit and vacate, and then they filed a summons and complaints to bring you to court. They have communicated.
So-
If you have vacated the property, your responsibility is to let them know that you have vacated and turn over the key.
Should they choose not to accept my calls?
You didn't, you testified one call. That was your testimony.
Yes, I'm aware.
We have enough for possession. You didn't turn over.
I'm not questioning.
Yeah, you
possession.
didn't
I'm
turn
just saying they
over,
took it
you
without
did
me
not
saying
turn
so.
over possession reasonably. That's not,
I just was
that's
under the
not
impression they
reasonable.
took it unlawfully.
Well, you left,
There was never a judgment for them to go in and drill out the lock.
you
and
mean,
give them
oh, what,
access.
when did they do that?
I have no idea.
So how do you know they did that?
Because I went there after our last court date when I was realized that they thought we were still there.
After the last court date when you told me you had vacated in May?
Yes, I vacated in May.
So you're saying in May, they drilled out the property and
I
changed the
have
locks?
I have no idea what their time frame for lock drilling was. I
No.
know in November when
You
I
went in
went there,
November.
the locks were drilled out.
After you've already communicated that
when I
you had,
found out that they thought
after
we
you
weren't
had
there.
already communicated that you didn't live there?
Yes. Because
So then
at
what's the
that
issue?
point, they thought the property was still mine.
No,
As
at that
far as
point,
that's
it's the
concerned.
middle of the winter
They're
and you
still
claim you
charging
left.
me for it.
In the middle of the winter, you claim that you left and you left all your stuff there.
No, I didn't.
And you said that it's not your responsibility to get it out.
Not the winner.
Judgment for the plaintiff
For possession or money?
and money. Done.
Thank you, Your Honor. Can I include candid cost in that?
Absolutely.
Thank you, Your Honor.
Thank
I'll
you.
get that submitted on e-filing.
Can I
Thank
object? I mean, can I
You
like?
can object all you want. I'm done. Thank you.
We weren't even there. They're getting just.
Do you want me to have you escorted out? Excuse me? You want contempt next? Because I can give you 93 days in jail.
What I like is all the other folks in the back of the courtroom are just sitting there going, oh, maybe mine will be a little bit better than this one. Thank you, Jennifer, for the gifted memberships. Thank you. That's awesome. I really appreciate that. Thank you so much for coming in. Hey, I put a link on there. I'm going to make sure I get the name of it right. There's a YouTube group called The Real Trial Junkies. They're just showing some court videos and stuff. And they start sharing our streams, and I thought that was really nice of them. And so me and the lady that runs that have been talking. And so if you're looking for a Facebook group to join, go join that one. Show them some support. At least stop by and just say thank you. I'm not a big Facebook guy. I've never been able to figure it out. For some reason, TikTok and other ones have been easier for me to figure out, but I don't know why. Every time I go on Facebook, it's like they've changed the rules, and I've got to learn it again. So. All right. Thank you guys so much. I'm going to get out of here. We're going to do Judge Fleischer tomorrow morning, and we'll do another American Courts Live tomorrow evening. Let me go find that credit thing, and that I don't know how to pronounce your name, buddy. JLOSO. I got you added to the next one. It's not going to be on tonight's, but it'll show up on there. I got you covered, bud. Thank you, and you guys have a great night.